Hello, everybody.
Richard Perez, two cases, 4A0281821 and CB0101264. Mr. Perez, good afternoon, sir. Or morning, sorry.
Hello.
All right. We're here for pretrial today. It does look like there's actually a change of plea, though, so I just have some questions I need to ask you, Mr. Perez, about this guilty plea statement. So, it is to several counts. It looks like count 1 is protection order violation. I just need to double check. These are all listed as DV, but the DV box isn't checked on any of these. Is that intentional?
They should have been DV, Your Honor.
Okay. Mr. Perez, when you went over the guilty plea statement with your attorney, were you aware that these are all domestic violence charges?
Yeah, I just got told just now.
Okay. So, Mr. Gardner, is it fine with you if I check the DV box?
If Mr. Perez is aware, that's what we're doing, I guess.
Okay. Alright, so Mr. Perez, count 1 is protection order violation, domestic violence. Count 2 is going to be protection order violation, domestic violence. And then count 3 is assault in the 4th degree, domestic violence. Pursuant to those guilty pleas, the city is moving to dismiss numerous other counts. It looks like 1, 2, 3, 4, 5 counts of protection order violation, domestic violence would be dismissed pursuant to those guilty pleas. Have you in fact had the opportunity then to review this document with your attorney?
Yeah.
Alright, do you have any questions about it for me at this time, Mr. Perez?
No.
Alright, on the defendant's signature line, I do see a signature. Did you sign that document electronically, sir?
Yep.
Alright, and do you understand, Mr. Perez, that by pleading guilty to these charges, you'd be waiving your constitutional rights, which does include the right to a jury trial and the right to remain silent?
Yep.
Alright, we're going to take a look at the recommendation here. Count 1, that's first count of protection order violation. It says 364 days, suspending 289. I'm not good at fast math, so let's see what that is. That's 75 days on count 1. Credit for any time already served towards that. Fine, $5,000. Suspending $48.50. That's a $150 fine. It says suspended all for a period of 24 months probation. We will get to those probation conditions in just a moment. Count 2 says 364, suspending 264, so that is 100 days there. $5,000 fine, suspending $48.50. That is again a $150 fine, and 24 months of probation. Count 3 also says 364, suspending 264, so 100 days there. $5,000 fine, suspending $48.50. That is a $150 fine, and count 3 says 60 months of probation, so that's 5 years of probation. The total then would be 275 days between all 3 counts combined, a $450 fine. 60 months of probation total. On that probation, it says obtain and complete a drug and alcohol evaluation, comply with the recommended treatment, complete a domestic violence evaluation, comply with the recommended treatment. There is a request for a post-conviction no contact order. As there is a request for an drug and alcohol evaluation, you would also be subject to testing, so that involves typically urinalysis. It can also be a breath test, an order not to possess or consume intoxicants, controlled substances without a prescription, and marijuana while on probation. I do need to ask, it does say the EHM box is checked. Is there some sort of agreement to release Mr. Perez to EHM?
Not that the city is aware of.
Okay. And then lastly, it does say, of course, there's no firearms, so as a result of these convictions, Mr. Perez, you would be prohibited from owning, possessing, controlling firearms until that right is restored to you by a court of law. There additionally would be a $115 domestic violence fee that's required by statute, so that would be imposed, as well as a $100 monthly probation monitoring fee. So it looks like that is the agreement here. Obviously, it's fairly substantial. Do you have any questions about that recommendation, sir?
No, I guess not. Like you said, it's pretty substantial.
Okay. I have a few more questions. Sorry, go ahead. I didn't mean to interrupt you.
I just never understood why it was so much.
Okay. I have a few more questions for you. If you need an additional moment to speak with your attorney after we get through this, I will certainly be happy to let you have that moment. But what I'm going to do, I'm going to finish asking my questions, and then we'll see how you wish to proceed here today, sir. So that is the recommendation. As far as what the recommendation is, I just want to be clear, you do understand what it is?
Yes, I do.
Okay,
275 days, right?
yes, that's correct. And
Okay,
the
all right.
probation.
Okay.
Okay, and do you understand, Mr. Perez, that the court is not required to follow this recommendation and could sentence you anywhere up to the maximum penalty on all three of these?
Yes, I do.
All right, other than this recommendation, sir, has anyone promised you anything or threatened you in any way in order to get you to plead to these charges?
No.
Okay, are you in fact doing this today on your own free will?
Yeah.
Okay. Lastly, are you also aware that if you're not a United States citizen, conviction of these crimes could carry negative immigration consequences?
Yes.
All right, I have one just extra question for you, Mr. Perez. You did indicate that you're not sure why the recommendation is so high. I can't tell you why a recommendation was made. That's not the court's part. All I can ask, do you need additional time to talk to your attorney about the recommendation, or are you comfortable proceeding at this time?
Well, I have to take it now because the prosecutor said if I don't, he's going to turn it into felonies. So in order for me to avoid that, I have to take it now.
Okay, all I want to make sure, and I just want to make the record crystal clear, are you entering into this plea because today this is what you want to do?
Yeah.
Okay.
Yes.
Okay. All right, Mr. Perez, I'm comfortable moving forward then. Mr. Gardner, are you satisfied on your end that Mr. Perez is making this change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
That's based on Mr. Power's representations, yes.
Okay. All right, Mr. Perez, I have to go through these one at a time. So on count one, under cause number CB0101264 to the charge of protection order violation, domestic violence, how do you wish to plead today, sir?
Guilty.
All right, on count two, under the same cause number, CB0101264, also protection order violation, domestic violence, how do you wish to plead today?
Guilty.
And on count three, cause number 4A0281821, charge of assault in the fourth degree, domestic violence, how do you wish to plead today, sir?
Guilty.
All right, thank you. And counsel, I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, go ahead, Mr. Bilbao.
Your Honor, I'm reading for the probable cause affidavit of Officer Mara. It's dated April 9th of 2024. On April 9th of 2024 at approximately 2013 hours, Pamela Fox Perez called 911 advising she had been assaulted by her husband, Richard Perez, at their residence on the city of Bellingham, Washington. Bellingham police officers arrived on scene where Pamela Fox Perez disclosed she got into an argument with Richard Perez inside the kitchen area of their home. Richard Perez was calling her various names in an aggressive manner. Pamela Fox Perez told Richard Perez to go outside because she felt threatened by Mr. Perez and did not want things to escalate. Mr. Perez was highly intoxicated at the time and had made threats to kill Pamela Fox Perez in the past. Pamela Fox Perez said Richard Perez then spit on her several times while calling her names in the kitchen area. Richard Perez then grabbed Pamela Fox Perez's right arm and pulled Pamela Fox Perez forward aggressively. Pamela Fox Perez was already standing in a stable position and did not fall. She did not have markings from this altercation but complained of pain in her arm. Pamela Fox Perez called 911 immediately after this occurred and Richard Perez went outside to the back shed. To include, Pamela Fox Perez had dried spit on her shirt and appeared in distress. She believed Richard Perez would further assault her if officers did not respond. Pamela Fox Perez's son, Nathan Walteri, and his sister, Michelle Fox, heard the interaction from downstairs. Michelle Fox advised she believed Richard Perez and Pamela Fox Perez were in the kitchen area due to the sound of their voices. Michelle Fox heard Richard Perez yelling and calling Pamela Fox Perez names and it appeared heated, so she stayed downstairs. Michelle Fox heard what she described to be spitting noises, and Pamela Fox Perez yelled for Richard Perez to stop spitting on her. Mr. Walteri believed Richard Perez spit on Pamela Fox Perez because he heard spitting noises as well as heard Pamela Fox Perez yelling for him to stop. Richard Perez was read his constitutional rights, at which time he disclosed to understand and wanted to speak with the officers. Mr. Perez first denied touching Pamela Fox Perez or spitting on her. However, after Richard Perez was placed in handcuffs, he said something similar to, "It just came out of my mouth when we were talking." Based on the above facts, probable cause existed for Richard Perez for assault with fourth degree domestic violence.
All right, and then as for the VNCOs?
And for this one, Your Honor, I'm reading from the report of Officer Mitchelson, dated April 17th, 2024. On April 17th, 2024, I was contacted by the City of Bellingham attorney Owen Kilfoyle, who reported that Pamela Fox Perez had left a voicemail message at the Bellingham Municipal Court complaining that Richard Perez was calling her from the jail in violation of the NCO. Kilfoyle sent me the voicemail message, which I reviewed. The message was left for DV advocate Cheryl Cartwright. Miss Pamela Fox Perez stated that Richard Perez keeps calling her from the jail. Pamela Fox Perez said that she answered one of his calls and reminded him not to contact her due to the no contact order. Pamela Fox Perez says that Richard Perez keeps calling her. I logged into the Whatcom County Jail phone system and researched Richard Perez's call history. The information generated showed that Richard Perez called Pamela Fox Perez's number 3 times on April 14th, 2024, twice on April 15th, 2024, twice on April 16th, 2024. It appears there was only one actual conversation which took place on April 14th, 2024, as Pamela Fox Perez stated in her voice message. I reviewed that conversation and listened to Richard Perez and Pamela Fox Perez talk to each other. Richard Perez asked Pamela Fox Perez to bring him his cell phone and put it in his property box at the jail. Pamela Fox Perez does remind Richard Perez there is no contact order. I have downloaded the recorded phone call and saved it in an Axon as evidence. Richard Perez was arrested for assault and 4th degree DV on April 9th, 2024 and booked into the jail. The victim in that case is Pamela Fox Perez. On April 10th, 2024, a pretrial domestic violence and contact order was served on Richard Perez. The order states in part that Richard Perez may not contact Pamela Fox Perez directly, indirectly, in person, or through others by phone, mail, or electronic means. The order is valid and does not expire until April 10th of 2099. On April 18th, I spoke with Pamela Fox Perez by phone regarding this investigation. Pamela Fox Perez confirmed she answered the first time Richard Perez called her from the jail because she thought he forgot there was a no contact order. Pamela Fox Perez says she reminded him about the order and said she would try to get his phone to him. This was consistent with what I heard on the recorded jail phone call referenced above. Pamela Fox Perez said that Richard Perez had continued to call after that, but she had not answered. Based on the facts of this investigation, probable cause exists to arrest Richard Perez for RCW 7.105.450, violation of a domestic violence no contact order, 7 counts.
Thank you. Okay. Based on that sworn testimony, court accepts your guilty pleas, Mr. Perez, on all 3 counts, finding that they were made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support all 3 guilty pleas. The court would find that all elements of all 3 counts have been satisfied beyond a reasonable doubt. The charges have been pled and proven. The court has now entered findings of guilt on those 3 charges. Mr. Kilfoyle, go ahead if you're ready on sentencing.
And Your Honor, at this time we're going to be asking to set the sentencing over to Friday morning. We didn't have confirmation that this was actually going to resolve today, so we just want to have the victim have an opportunity to provide any input for the sentencing here. Our office has been in good communication. I do expect that we will have some sort of input, or she will be present to provide her statement at that time. Considering the amount of time that the defendant is facing, the setting over to Friday in custody shouldn't be any sort of an issue. That would be the city's request.
Okay. See, he has been in custody for a pretty significant period as well. I think it's been since April. Mr. Gardner, any objection to the 2 days?
I would just defer to Mr. Perez. Mr. Perez, do you have any problem setting this over to finish sentencing on Friday?
Well, you guys can do it without me, can't you?
No.
I don't need to get drug all the way over here.
Unfortunately, no, sir. You need to be present for sentencing. The alleged victim, or victim at this point, as there has been a finding of guilt, has the right under Washington law to be present at sentencing, and it sounds like the city didn't have an opportunity to bring them or let them know that this was occurring today. So,
Well, they should have, in my opinion. They should be ready. I'm here ready. They should have been ready and had whatever they're going to do, because I came here to be sentenced and done.
So,
I'm not. I don't want to come back here again.
Mr. Perez, it sounds like there was no confirmation that this was actually resolving here today. So,
Absolutely not.
So I'll note your objection, Mr. Perez, but I have to follow the law here in Washington and give the victim the opportunity to be heard. So I am going to grant the city's request to set this over to Friday morning. That's October 25th at 8:30 for sentencing. So today we are not moving forward with sentencing.
The only other thing the city would add is I am uploading the post-conviction no contact order now, so that the court can review it with
that.
the
Okay.
defendant.
All right, I'll be just a minute. So I'm entering the findings of guilt, but I'm not obviously doing the sentencing here. Mr. Kilfoyle, just to maybe make it cleaner on Friday, are you fine moving forward with the other dismissals today?
I'm fine with doing the dismissals today. The city would move to dismiss 5 of the VNCO counts. At this time, the domestic violence charges, we would be doing that with prejudice.
All right, any objection there, Mr. Gardner?
No objection.
City's motions granted. 5 counts protection order violation under the 264 cause number are dismissed with prejudice. It is going to take me a minute to get that entered on the order here. Okay, so the last thing I'm just doing on the order here is obviously putting the sentencing date on there. So October 25th, 8:30. Council, if you don't mind signing off on the judgment and sentence in just a moment, because it is effectively our continuance here today. I'll get out of the document.
I'm signing the judgment and sentence.
Yes, because that the new. If you look at the top of the JNS, there I have sentencing set over to October 25th. So it's basically our continuance. The only other thing on the JNS at this time is the guilty findings and the dismissals on the other BNCOs, and we'll enter a fresh JNS on Friday with obviously all the other relevant information.
Mr. Perez, can I sign your signature on here? Just an acknowledgement that we're setting it over until Friday.
Just to be clear, Mr. Perez, it's not that you're in agreement with it. I've noted
No.
your objection for the record.
You're just acknowledging that the court's moved your sentencing hearing to Friday.
Yeah, well, nothing I can do about it.
That is close to, yeah, you can object, and I think you've already done that.
It don't
So
matter.
is it all right if I sign that you've been told that your sentencing is moved to Friday?
Yeah,
Mr. Kilpo, can you sign off on the guilty
pretty obvious.
Absolutely.
well.
And that NCO is ready. Your Honor, it's the one that has the 2 case numbers.
All right.
We could probably do that on Friday too, couldn't we? If we want to do it now, though, we can do it now.
Yeah, let's get this done.
Okay. We can't complete the process.
Here, what
Today,
I'm
Mr.
going to do,
Perez.
Mr. Perez, is we are going to go through the no contact order right now. I see 2 loaded up, Mr. Kilfoyle. Are we entering 2 separate ones?
No, I saw that there was one that was uploaded on 1 case number. The one I filled out has both case numbers.
Okay, all right. So just the one with both case numbers.
Correct,
Okay.
Your Honor.
So, Mr. Perez, the order does protect Pamela Fox Perez. It does prohibit you from doing a number of things. Do not cause, attempt, or threaten to cause bodily injury. This does include any type of assault, harass, stalk, or keep under surveillance the protected person. You are simply to have no contact with them at this point. That does include face-to-face through a third party. Electronic and written contact are included, so texting, phone calls, emails, social media. Do not knowingly enter, remain, or come within 1,000 feet of the protected person's residence, school, workplace, vehicle, or wherever they might be. These convictions do prohibit you from owning, possessing, controlling a firearm. That is noted on this order here, and you would have to immediately surrender any firearms or the other dangerous weapons to the Bellingham Police Department. This, at this time, is going to be a 5-year order, so it will remain in place until this date, which is October 23rd of 2029. Additionally, sir, I just need to let you know that as a result of these 2 convictions, any subsequent no contact order violations could and likely would be filed as felonies, just so you are aware. So it is very important that you follow this no contact order. Do you have any questions about that order, Mr. Perez?
Well, it's hard to measure 1,000 freaking yards or whatever if I see somebody somewhere. I mean, that's just crazy. If I'm in a store trying to buy groceries and that person suddenly is in that store, I'm supposed to just drop everything and run?
That is essentially correct. So the order includes, the order, Mr. Perez, is a knowledge order. So if you do not know that you're within 1,000 feet of the protected party, that's not a violation of the order. But if you see and become aware that you're within 1,000 feet of the party, then your obligation under the order would be to leave. That's how that works.
All right.
And again, can I sign your acknowledgement? You understand what the order prohibits? Can I sign that you've been told of those conditions and that you understand them?
Yep.
Okay, Mr. Perez, I understand your frustration, sir, but I appreciate your patience. We're going to see you on Friday morning, and we will get this resolved once and for all for you, sir. Thank you.
Yeah.
Be safe, be well, sleep sweet, and much love.